Hey guys, it's attorney Anthony Bandiero here, bringing the Roadside Chat. This question comes from an officer in South Dakota. It's a very common question, and I know that a lot of you have this question. Basically, it's this: can police be held liable if they do not prevent someone's suicide? Okay, so pretty much a hot topic right now because a lot of people are asking, how much intervention should police do in some of these calls, especially when the allegation is that just one person is contemplating suicide and nobody else is in danger, right? The situation where the sister called the brother made comments about maybe taking his own life. He's alone, he lives alone. The police arrive, he's not answering the door. Do we make a forced entry? Those type of situations. What should we do? Well, I can't tell you what you should do, but I do want to present to you what the Constitution says about your obligation to prevent harm. Okay, so the first principle that we got to get out of the way is, do you have a duty to prevent a person's suicide, right? And the answer is no, you do not. This concept is founded in a case called DeShaney versus Winnebago County. It's a U.S. Supreme Court case. And basically what happened there is a young boy named Joshua was being abused by his father. Child Protective Services had some information regarding this. They knew or should have known that the father was a danger to his son. They investigated it. By all appearances, they did a really crappy job and did not take Joshua into protective custody. Joshua ended up getting beaten to a point where he was practically brain dead. And the mother sued Winnebago County for their lack of intervention, right? Not doing enough. They could have done more. And as sad as this situation is to poor Joshua, at the end of the day, did Winnebago County violate the Constitution? And according to the U.S. Supreme Court, the answer is no, because people do not have, Joshua or the suicidal subject, people do not have a constitutional right for intervention, right? For you to intervene on their behalf to prevent them from hurting themselves. That's just not the way it works, right? And I think it has to be this way, because if it was reverse, you could probably always Monday morning quarterback police performance, right? If police would have done this, if they would have responded quicker, a life would have been saved, right? If they would have not gone in, a life would have been saved, because sometimes when police force a confrontation, the suicidal subject will have you kill them, right? Because it's, in my opinion, much easier for you to kill them, for them to kill themselves, right? It's just easier. So all these situations are very dynamic and they're stressful, and emotions are high. So it has to be that way. Otherwise would be an endless litigation, right? So let me give you an example of what I'm talking about from a real case. Okay, it's McGrain versus City of Philadelphia. The citation from Lexus, right, is 2006 U.S. District Court, Lexus 66051. Okay, so here's the basic background of the case. This lady was staying at a hotel. She was abusing drugs and alcohol and was suicidal. Her family came and then called the police. The family wanted to admit the girl to a hospital to ensure she did not harm herself. But the police said, look, based off of what we see, we don't have the authority to take her into protective custody. In other words, it seems to me that they did not feel that there was an imminent or immediate threat of self-harm. She was probably just saying, look, I'm fine, that type of stuff. So police did not believe that they actually had the authority to commit her. Okay, so there's the key issue in this case, right? is the fact that they did not do that. Now, they did promise to go to a doctor to try to see if he would sign off on a commitment. So they went to the hospital, they presented the facts, the doctor did sign off on a commitment, and that took about 3 hours. They returned to the hotel, knocked on the door. I guess she knew that she was about to be committed. So instead, she jumped out the window and severely injured herself. She did not die, but she was substantial injuries. Then she later brought a civil rights lawsuit against the police. This is called a Section 1983 lawsuit, that the police violated her rights. So, alleging that they violated her rights under the 4th and 14th Amendment. Specifically, she claims that she was deprived of her right to be secure in her person and property and to due process and equal protection of the law, and deprived of her right to prompt and appropriate medical care and attention. She also brought some other state claims, which are outside the scope of this video. So here's basically what the court said. McGrain's allegations all center on actions that the state did not take. Allegedly, the state was guilty of failing to call an ambulance and or failing to transport the plaintiff to the hospital, psychiatric facility, and or failing to have the plaintiff committed, and failing to obtain the needed medical or psychiatric attention. These allegations, by their very terms, refer to a failure to act instead of an affirmative action. The Third Circuit and others, right, has unequivocally held that the liability under state-created danger theory must be based on an affirmative action of the state. Keep that in mind. If the state is not doing anything specifically to put that person into danger, especially a foreseeable danger, right? But they have to do something. Not only has to be foreseeable, but they have to do something. Did the police officers do something to make her more likely to injure herself? If the answer is no, there's generally no liability under the Constitution. Okay, police have to do something affirmative. Otherwise, again, there would be an endless litigation. At bottom, she has alleged only the state failed to protect her from herself and failed to provide competent rescue services. As noted above, such claims do not constitute due process violations. See DeShaney. And accordingly, McGrain has failed to present a claim on which relief may be granted. She has not specifically alleged that the officers placed her in a dangerous position. She has not stated the officers used their authority to create an opportunity that would otherwise not have existed to harm herself, right? Further, the fact that the state may have temporarily had McGrain in custody in the hotel's lobby is not determinative. In DeShaney, where the state had taken Joshua into temporary custody, the Supreme Court stressed the state does not become the permanent guarantor of an individual's safety by having once offered him shelter. All right, my friends, there's some case law for you. Okay, do the best job you can to save people from harm, but also realize that you are making decisions out there, and we also should not be grabbing people off the street, in my opinion, and locking them up in a against their will, right? Locking them in a psychiatric facility for an evaluation when the police officer did not have the facts or circumstances lead a reasoned person to believe that the person was an imminent or immediate threat to themselves or others. Look at what your state law says, but generally speaking, you get the authority to involuntarily commit somebody when they are a threat to themselves or others. But if you have the situation where people are in an argument with their spouse and they say things like, I'm going to kill myself if you leave me, but then later when the cops arrive, the person is calm or calmed to some extent, but he says, look, yeah, I said those things in the heat of the moment, right, to get my wife's attention and so forth, but I'm not a threat to myself. I am fine. And there are no other facts to believe that this person is going to harm themselves or others immediately or imminently once the police leave. I think police should be careful. I think that, taking that person against their will and committing them could cause other problems. I mean, that might actually end up being in itself a violation, because it may not be, it may not comport with what the state requires. So it goes both ways. But the point is, do the best job you can out there with the facts that you have. I hope this helps, right? It's a very tough situation. Do the best job you can. All right. And with that, if you found this information useful, hit the like button, subscribe, share with your friends, pass the video around if you think this will help your partners, right? And until next time, my friends, keep up that great job.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.